Now you can get FUCT, circle R, clothing. Today, the Supreme Court struck down a major provision of the Lanham Act, that's our trademark law, that prevents the registration of quote unquote obscene and scandalous material. If you stay with me for the next 5 minutes, I'm going to talk about what that means. And if you stay until the end, I'll offer you a free resource about other things that you can't register as trademarks. I'm Angela Langlotz, and I go live here every weekday to talk trademarks and copyrights. And today I want to talk about a huge case that was just decided by the Supreme Court that involves scandalous and obscene matter, or what I like to call naughty trademarks. So the mark in question was for clothing and a whole bunch of other stuff, which I'll show you in a second. And the mark was FUCT, commonly pronounced FUCT. Now, I'm not swearing for reals here. In fact, during the proceedings, the attorneys for the government noted, they said, the mark would be perceived by a substantial segment of the public as the equivalent of the profane past participle, I love the alliteration there, of a well-known word of profanity. Indeed, it is a well-known term of profanity. But in any case, a man named Brunetti wanted to register a trademark for his clothing line, which is supposed to stand for friends you can't trust. Yeah, right. We don't buy that. But let's have a look anyway, and I'll show you all the marks he tried to register. So let me scoot this over a little here. And here is the whole list of things. I'm just going to call them the FUCT marks that he tried to register. Now, you'll note that many of them are dead. I presume he tried to register those earlier and failed. However, he applied to register quite a while ago, actually. Let's look at the oldest live mark. So this was for athletic apparel, and this was applied for May 30th, 2011. So this fight has been going on quite a long time. Now, those of you who are familiar with the way the Supremes work is that you have to go to a lower court first, plead your case, and then if you get refused, you can appeal to higher and higher courts. Now, the Supreme Court took this case. It's very rare for the Supreme Court to take any case because, you know, hundreds of petitions arrive at the Supreme Court every year seeking certiorari, seeking redress before the Supreme Court, and the vast majority of those are refused. Now, this, I think, was accepted because of the nature of the case. In its opinion, the Supreme Court noted that the problem with the Lanham Act was that it wasn't viewpoint neutral. In other words, the Lanham Act said that you can't register things that are disparaging, right? So if you have a disparaging viewpoint, your mark will not be registered. But if you have a laudatory or congratulatory viewpoint, that will be registered. And the Supreme Court noted, and correctly, I believe, that you can't have a privilege like that, a right to register your trademark, be viewpoint it has to be viewpoint neutral. You can't just say, well, we're going to accept these registrations because we like the viewpoint, it's not disparaging, and we're going to reject these registrations because we don't like the disparaging viewpoint. That is not constitutionally permissible. And I'm going to quote the court here. They say, material is scandalous under the Lanham Act when it gives offense to the conscience or moral feelings. So the Lanham Act, that's again our trademark law, allows registration of marks when their messages accord or agree with the society's sense of decency and propriety, but not when they go against it. And they said, this is not constitutionally permissible. Now, the interesting thing about this ruling is that it made for some strange bedfellows among the justices of the court, with the conservatives and the liberals agreeing, and liberals and conservatives dissenting. So it was interesting that Thomas, Alito, Kavanaugh, and Gorsuch, who are considered more conservative, actually sided with liberals Kagan and Ginsburg in striking down this portion of the Lanham Act, while liberal justices Breyer and Sotomayor sided with conservative Justice Chief Justice Roberts. So it was a very interesting decision, and I'm still reading the whole thing, but I did read the summary. It's very interesting, and I support absolutely the right of everybody to have free speech, and I'm proud that our Supreme Court is affirming that right, that speech be viewpoint neutral when we're talking about government regulation. So as an aside too, I'll note that all of you who are afraid of some lurch to the right of the Supreme Court, I think that this ruling puts those fears to bed, because we have conservative justices agreeing with the left and leftist justices agreeing with the right. So I think we're pretty much assured that our Supreme Court is going to continue to respect our rights to free speech and our right to self-determination here in the United States. And I'm proud of the decision that they made here today. Now, the interesting question, though, is now where is the line? Basically, what they said was, listen, if Congress wants to more narrowly tailor these restrictions to be viewpoint neutral, that's okay. But they're going to have to rewrite the Lanham Act to comport with this ruling. They're not going to be able to have the Lanham Act be supportive of certain viewpoints that are non-disparaging and prohibit other viewpoints that are disparaging. So it's back to the drawing board for the Lanham Act. Congress is going to have to get together and write up something new that conforms to the dictate that the Lanham Act be content neutral. Or at least viewpoint neutral. I'm Angela Langlotz, and I go live here to talk about trademarks and copyrights and the occasional Supreme Court ruling. You can find me online at TrademarkDoctor.net. You can also find me on Facebook at facebook.com/TrademarkDoctor. And if you message me your questions, I will respond to those on a future live video.